Imagine tripping over a cracked sidewalk. It's, embarrassing. Maybe you walk away with a scraped knee or a bruised ego.
Right, yeah. A completely normal accident.
Exactly. But now imagine that exact same trip, but instead of just walking away, you were immediately rushed into an irreversible spinal fusion surgery.
Which sounds completely insane.
It really does. And all because a private equity firm in Bahrain needs to hit its quarterly profit targets. Welcome to today's deep dive.
Yeah, that premise, it forces you to completely reevaluate what an accident actually is. I mean, you have to stop looking at a slip and fall as a clumsy, isolated incident,
Great.
and you have to start viewing it as the opening scene of this highly choreographed, industrialized system.
Which brings us directly to the massive document we're diving into today. We have a civil RSA Co. complaint. That's the Racketeer Influenced and Corrupt Organizations Act, filed in the U.S. District Court for the Eastern District of New York.
A very serious piece of litigation.
Oh, absolutely. And the plaintiffs bringing this suit are subsidiaries of Amtrust Financial. Specifically, we're looking at Wesco, Technology Insurance Company, and Associated Industries Insurance Company.
Right, and those are the folks who insure the, small and mid-sized businesses all around you, the deli, the contractor.
Exactly. And the defendants on the other side of this are just this sprawling network of personal injury lawyers, medical clinics, surgeons, surgery centers, and litigation funders.
It's a huge cast of characters.
It really is. And our mission today is to decode the architecture of this alleged, and we do have to emphasize, alleged association, in fact, enterprise.
Right. These are allegations in a lawsuit.
Yes. Very important to note. We're going to look at how the civil legal system and the healthcare system are purportedly being weaponized for pure profit.
Okay, let's unpack this, because we aren't just talking about a few exaggerated injuries here.
No, not at all.
We're looking at the literal manufacturing of multi-million-dollar lawsuits. Yeah. To understand the sheer scale of what Amtrust is alleging here, you really have to look at this enterprise as a perfectly integrated supply chain.
A supply chain.
Yeah, exactly like a factory. Every single entity involved relies on the others to basically bypass standard fraud detection.
Okay, I see.
So the raw material entering the factory is a staged or manipulated accident, right? And the finished product rolling off the assembly line is this impenetrable, mathematically optimized insurance claim.
Okay, let's walk through that assembly line then, and meet the cast of characters, starting right on the ground floor.
Sure.
At the very beginning, you have what the complaint calls runners. These are individuals whose entire job is to recruit vulnerable claimants.
Right. And they specifically target non-English speaking immigrants, often promising them a quick, easy payday.
Wow. So they're going after people who might not fully understand the system.
Exactly. The runner coaches them on exactly how to stage the accident, where to say it hurts, and then they physically transport them to the next stop on the line, which is the law firm.
And in the framework of this specific complaint, the central legal architects managing this whole flow are alleged to be Liakas Law, right? Specifically, Dean and Nicholas Liakas.
That's right. Once the claimant signs a retainer with the firm basically takes over the logistics.
They start managing the products.
Yeah, they funnel the individual to a very specific network of what the complaint identifies as gatekeeper clinics.
Gatekeeper clinics.
Right. These are physical therapy and rehab centers that they don't really operate to heal. They operate to generate templated, uniform medical records.
Wait, I want to pause on the medical aspect for a second. Because the gatekeeper clinics bring in radiologists to write up these, terrifying sounding reports.
Oh, absolutely. They sound catastrophic on paper.
And that gets the claimant to the final and most lucrative stop, which is the surgeons. The complaint names practices like Gotham Neurosurgery with Dr. Anders Cohen and McCulloch Orthopedic Surgical Services.
Right, operating out of places like Hudson Regional Hospital or the Empire State Ambulatory Surgical Center.
But here's my question. If the goal is just to fake an injury and get an insurance payout, why go to the extreme of performing spinal fusions? I mean, why not just claim a broken arm or a torn rotator cuff?
What's fascinating here is the deliberate choice of the spine. I mean, a broken arm is a terrible anchor for a fraudulent lawsuit.
Because of the x-ray.
Exactly. An x-ray is binary. The bone is either fractured or it isn't. You can't really fake that.
That makes sense.
A spinal fusion, on the other hand, relies heavily on subjective patient complaints of chronic pain, right? And soft tissue MRI readings that can be highly open to interpretation.
Oh, wow. So there's gray area they can exploit.
Massive gray area. And more importantly, Spinal surgeries trigger the absolute highest insurance billing codes in the entire medical system.
So it's about maximizing the dollar amount.
Always. By cutting into a perfectly healthy or perhaps just mildly naturally degenerating spine and fusing vertebrae together, the surgeons are creating a catastrophic injury out of thin air.
That is just, it's horrifying. They're essentially physically, permanently damaging these recruits just to inflate the spreadsheet value of the claim.
Yeah, it's really dark. There's even a detail in the complaint about a podiatrist, Dr. Siddhartha Sharma, who allegedly didn't even maintain standard ankle privileges in New York.
Wait, a podiatrist?
Yeah, but he was somehow seamlessly integrated into this highly complex surgical pipeline.
The human toll of that is just staggering to think about. But let's look at the financial engine keeping this whole factory running, because you can't just convince someone to undergo a fake spinal fusion for free, right?
I would definitely not.
You need capital. Enter the funders. These are litigation finance companies that step in to advance money to the claimants.
Right, and the complaint highlights one specifically called Jumpstart Funding, LLC.
Yeah. And the role of the litigation funder is critical for keeping the claimant trapped, isn't it?
It's the glue of the whole operation. When a vulnerable worker is recruited, they're often told they can't work while the lawsuit is pending, right? Just to make the injury look completely legitimate.
Right, because if you're paralyzed with back pain, you shouldn't be working construction.
Exactly. So suddenly they have no income. The funder swoops in and offers them a cash advance to pay rent or buy groceries.
Oh, I see.
But they do this at usurious, aggressively compounding interest rates.
It kind of makes me think of a movie studio financing a blockbuster.
Mm-hmm.
The litigation funder is basically the executive producer here.
That's a really good analogy, actually.
Right, like they're fronting the cash for the special effects, which in this case is the surgery and the claimant's living expenses, because they know it guarantees a massive box office payout when the settlement finally hits.
Yeah, and the numbers are specifically designed to just devour the claimant's share.
How bad does it get?
Well, say a worker takes a $10,000 advance at a 50% compounding interest rate. By the time the lawsuit settles 3 years later, they might owe $40,000 just on that initial advance.
Oh my goodness. That's criminal.
And then the lawyers take their 33% contingency fee. The surgeons take $150,000 for the operation. The claimant is left with virtually nothing.
Nothing but a permanently fused spine.
Exactly. And to add another layer to your executive producer analogy, Amtrust alleges that Jumpstart Funding LLC is actually owned in part by the principals of the Liakas firm itself.
Wait, really? So the lawyers are securing the claimant, the doctors are inflating the medical damages, and the lawyer's own side hustle funding company is fronting the cash.
That is the allegation, yes.
They're quite literally loan sharking their own clients to guarantee they never back out of the scheme.
It completely closes the economic loop. I mean, everyone is making money off the manufacturer crisis, and everyone is validating everyone else's paperwork.
Okay, but this brings up a huge question for me. If these clinics are churning out identical templated MRI reports and just scheduling unnecessary spinal fusions left to right, why doesn't Amtrust or Wesco just toss the claims in the trash?
You'd think they would, right?
Yeah, I mean, it seems like an obvious fraud. Why don't they just point to the pattern and refuse to pay a dime?
Because the enterprise is weaponizing a statutory trap built directly into New York law. It's called the duty to defend.
The duty to defend. Okay, what does that mean exactly?
So the moment a civil complaint is filed, even if it's entirely fabricated from whole cloth and just verified by Dean Liakas, the insurance company is legally obligated to incur immediate defense costs to protect their insured client.
The moment it's filed.
The very second. The meter starts running at like $500 an hour for defense attorneys the second that paperwork hits the docket.
Wow. Okay, let's put the listener in the shoes of a small business owner to make this really concrete. Say you own a corner bodega. You have a general liability policy with Amtrust that covers up to $1 million.
Okay, classic setup.
A runner stages a slip and fall on your sidewalk. The Liakas firm files a lawsuit against your bodega for $5 million, citing a life-altering spinal fusion. Even if you, the bodega owner, have security camera footage showing the guy basically laying down gently on the pavement.
Which happens.
Right, but Amtrust still have to defend you.
They absolutely have to, and that leads to the ultimate weapon in this whole scheme. It's the concept of extortion through fear of economic harm, as defined under the Hobbs Act.
Extortion, so they're holding the insurer hostage.
Basically, yeah. The insurance company knows the surgery was likely a sham, but they have to calculate the real-world risk of putting that case in front of a jury.
Because juries are unpredictable.
Exactly. And jurors don't get to see the runner recruiting the claimant in a back alley. They are presented with the paper truth.
The paper truth. You mean the stack of pristine medical records?
Yes. A mountain of MRIs, physical therapy logs, and operative reports that are signed by state-licensed doctors.
So even if the medical records are entirely fabricated at their source, they look objectively real in a courtroom setting.
Totally real. If Amtrust decides to fight your bodega's case at trial, they are really rolling the dice. If a sympathetic jury sees a plaintiff with a surgically altered spine, believes that paper truth, and hands down a $5 million catastrophic verdict.
Oh, wait. Your Amtrust policy only covers the first $1 million?
Exactly.
Leaving me, the bodega owner, personally on the hook for the remaining $4 million, I would lose my business. I would go completely bankrupt.
And then you probably turn around and sue Amtrust for bad faith.
Because they had the chance to settle the case within my policy limits, and they chose to gamble with my livelihood instead.
Which is exactly why the insurance company is essentially forced to settle. The scheme isn't about winning a fair intellectual debate at trial.
No, it's about leverage.
It's about artificially inflating the stakes so high that the cost of fighting becomes astronomically dangerous. The surgical escalation makes settling the only rational mathematical business decision for the insurer.
That is wild. They're quite literally monetizing the risk parameters of the civil justice system.
That's a great way to put it.
But wait. If the legal trap requires absolute unshakable control over the medical paperwork to create that paper truth, they can't just rely on random doctors.
No, they need a sure thing.
Right, because a legitimate independent surgeon might look at the patient and say, you don't need a fusion, just go home and rest. They would have to own the clinics outright to actually mandate the surgeries. But wait, in New York, corporations and private investors can't legally own medical practices, right?
That's right. New York enforces the corporate practice of medicine doctrine very strictly. The law mandates that medical clinics must be owned and controlled by licensed medical professionals.
Okay, to protect the patients.
Right. The policy goal is straightforward. Patient care must be prioritized over corporate profit. You cannot have businessmen dictating medical protocols just to hit financial targets.
But the complaint alleges they found a massive loophole to get around this. They detail a corporate entity called Health Plus Management, or HPM, operating under the umbrella Musculoskeletal Resources.
And in 2019, HPM was actually acquired by InvestCorp, which is a foreign private equity firm based in Bahrain.
Wow. And the allegation is that HPM represents this institutional-grade violation of the corporate practice of medicine. It's what people call a doc-in-a-box scheme.
Yeah, the classic doc-in-a-box. The doctor's name is painted on the front door, right?
Yeah.
It looks legitimate. But HPM, the private equity-backed management company, secretly controls the marketing, the hiring, the human resources, and the internal referral networks.
And the complaint offers some incredibly dense financial documentation to prove this. It's kind of hard to read through.
It's very dense, yeah.
They mentioned that over just a few days in the fall of 2019, HPM perfected security interests in the entire accounts receivable of multiple clinics, specifically DHD, NJS, PMR, and SMSR. But hold on, perfected security interests. What does that actually look like in practice? Does that mean the private equity firm effectively holds a mortgage on every dollar the clinic hasn't even made yet?
That is a perfect way to translate it, honestly. By perfecting a security interest in the accounts receivable, the private equity firm takes absolute legal ownership of the clinic's future cash flow.
Oh, wow. So the doctor is totally trapped.
Completely. If the on-paper physician tries to step out of line or, refuse a referral or prioritize genuine patient care over the surgical quota, HPM can financially asphyxiate them instantly.
So it legally turns the physician owner into a highly paid, subordinate employee of a non-physician, profit-driven entity.
Exactly.
And the micromanagement is blatantly documented in the complaint. The text includes phone call logs for a Dr. Ashley Simla, who supposedly became the new independent owner of the DHD clinic.
Yeah, these logs are revealing.
If you're a doctor taking over a medical practice, your first calls are going to be to medical suppliers, hospital administrators, maybe former colleagues to build out your staff, right?
Yeah, you would be setting up the infrastructure for actual patient care.
According to the subpoenaed logs, Dr. Simla's very first phone call as a clinic owner was to a physical therapy facility connected to a guy named Fabio Aguiar.
And Aguiar is a known runner who explicitly marketed himself to non-English speaking construction workers.
Right. Then, Dr. Simela's second call was to Paula Lapis, the Director of Business Development at Hudson Regional Hospital, which is exactly where the enterprise funnels all the surgeries.
Yep.
And his third call was straight to Nicholas Liakas, the personal injury lawyer.
If we connect this to the bigger picture, you really see the true danger of the doc-in-a-box model. When you introduce private equity from Bahrain and completely remove physician autonomy, the ultimate goal of a healthcare facility fundamentally shifts.
It stops being about healthcare.
Exactly. It goes from patient healing to profit maximization via rote protocol schemes.
Here's where it gets really interesting, though. The corporate audacity doesn't even try to hide itself. The complaint points out that HPM maintains a separate concierge website specifically to market these medical clinics directly to personal injury attorneys.
Yeah, it's pretty brazen.
They have completely abandoned any pretense of traditional patient care. They're essentially advertising themselves as a one-stop shop for manufacturing medical damages.
And the machine is fully built at this point, right?
Yeah.
The lawyers are ready to trap the insurers, the private equity firm controls medical narrative, and the funders are providing the cash flow.
It's all set up.
The only thing the assembly line needs now is bodies to put through the gears.
And the data analyst at Amtrust found a geographical pattern regarding those bodies that is just mind-blowing. They call it the Jarabacoa anomaly.
The Jarabacoa anomaly.
Yes.
According to the data in the complaint, a statistically impossible number of claimants represented by the Liakas firm all hail from the exact same small town in the Dominican Republic, Jarabacoa, which only has a population of about 70,000.
These individuals immigrate to the U.S. and all magically move to the same specific suburb in Long Island, Freeport.
And this is where the data just becomes completely absurd. These residents of Freeport, Long Island, magically suffer severe, catastrophic trip-and-fall accidents on sidewalks in entirely different boroughs, the Bronx, Brooklyn, and Queens.
All of them.
Yeah. The pattern was so egregious that New York Governor Kathy Hochul actually cited this specific geographic anomaly in a 2026 address about combating insurance fraud.
I look at it as a bizarre Bermuda Triangle of tripping. I mean, I want you to imagine the sheer statistical impossibility of hundreds of people from your exact foreign hometown moving to your exact American suburb, and then all of you individually commuting to random disparate parts of the city just to trip over specific cracks in the pavement.
It's unbelievable.
And then, defying all odds, you all end up with the same lawyer, you go to the same private equity-owned clinic, and you all receive the exact same spinal fusion surgery.
The odds are astronomical. And the final piece of the puzzle here is the timeline of these lawsuits, which completely exposes the artificial nature of the whole enterprise.
How so?
Well, in New York, the statute of limitations for filing a personal injury lawsuit is 3 years.
Meaning you have 3 years from the exact date you fall on the sidewalk to officially file the paperwork in court.
Right. Now, the complaint outlines that the Liakas firm's case filings skyrocketed and peaked in 2022, but then they plummeted sharply in 2023 and 2024.
Why the sudden drop?
Because the massive batch of staged accidents occurred during the height of the scheme in 2020. The firm simply sat on the claims to build up the medical paperwork, letting the interest compound.
Oh, wow.
And then they dumped them all onto the court docket right before the 3-year ticking clock expired.
So the sudden drop-off in lawsuits aligns perfectly with the moment the statute of limitations passed for that initial 2020 cohort of staged accidents.
Exactly. It is purely a numbers game. They are processing cohorts of humans like batches of inventory.
That is so bleak.
It is. This raises an important question, though, and it's the anchor we really cannot lose sight of amid all this talk of private equity loopholes and statutes of limitations.
Right.
We're analyzing corporate structures, billing codes, and data anomalies. But actual human beings, often vulnerable non-English-speaking immigrants who were promised an easy solution to their financial struggles, they were subjected to irreversible, highly invasive spinal surgeries.
Their bodies were permanently altered.
Yes, permanently altered just to pad an investment portfolio and a law firm's bottom line.
So what does this all mean for you? You might be listening to this thinking, well, I've never faked a slip and fall, I don't own a clinic, and I'm not an Amtrust insurance executive, so this is just a wild true crime story that doesn't affect my life.
Right, it feels distant.
But you are absolutely paying for this assembly line. Fraud-driven claim inflation completely distorts the medical system. It clogs up the civil courts so legitimate grievances, people who actually suffered real injuries through no fault of their own, they cannot get a hearing.
Exactly.
And most directly, it increases insurance premiums for every single small business out there.
Yeah.
The deli on your corner, your local contractor, your favorite neighborhood restaurant.
Yep.
When insurers bleed millions of dollars to extortionate schemes, those costs don't just vanish. They're passed on to the business owners, who then pass them on to you every time you buy a sandwich or hire a plumber.
It acts as a massive, invisible tax on the entire local economy. And I will leave you with a final, somewhat provocative thought to mull over.
Okay, let's hear it.
If litigation funding, aggressive legal tactics, and private equity loopholes can already turn the human body and the civil justice system into a highly predictable, risk-free financial asset class, what happens in the next 5 years?
Oh, man. With technology accelerating.
Exactly. What happens when these networks start using artificial intelligence to optimize their accident staging locations based on algorithmic blind spots in municipal camera networks?
That's terrifying.
Or what happens when they use AI to automatically generate perfect, statistically unassailable, templated medical records at a scale that human auditors can't even process?
They wouldn't even need the gatekeeper clinics to do the paperwork.
Right. Will technology finally give regulators and insurance companies the tools to catch the fraudsters, or will it just make the dock-in-a-box scheme truly, terrifyingly invisible?
It makes you wonder. The next time you're walking down the street and see someone trip on a crack in the sidewalk, are you watching a genuine, clumsy accident? Or are you just a background extra standing on the set of someone else's multi-million-dollar corporate production?